You know, usually when we sit down to do one of these deep dives, we're looking at something pretty public.
Right.
A news report, a viral article, maybe a white paper that's been floating around the internet. It's stuff you could find if you spend an hour on Google.
Right. It's usually already part of the public conversation. We're just connecting the dots.
That's the usual gig. But today is different.
It really is.
We have our hands on something that feels, well, frankly, it feels like we shouldn't have it. It's a document that usually lives in a locked file cabinet inside a prosecutor's office, buried under a stack of confidential stamps.
It's the kind of paperwork that changes lives, but nobody ever sees the gears turning. You only see the result.
We are looking at a model federal charging memorandum. And I know that sounds incredibly dry.
It sounds like homework.
It sounds like the tax code had a baby with an instruction manual. But when I started reading this thing, authored by scientific analyst Justin Lake, my jaw actually hit the floor. Because this isn't just paperwork. This is a blueprint for how the government decides to put one of its own agents in prison.
It really is the dark matter of the legal world. We see the explosion, the news story, the shooting, the protests. But this document is the gravity holding it all together. It's a what-if analysis.
A what if?
Specifically, it is a forensic deep tissue breakdown of the fatal shooting of Renee Nicole Good in Minneapolis.
And that is the mission today. We aren't here to debate the politics of immigration or policing in the abstract.
No.
We are going to do something the news rarely does. We are going to put on the prosecutor's glasses. We are going to look at the exact same video evidence, the exact same federal statutes, Title 18, the Fourth Amendment, and we are going to ask, is the law actually clear?
And that is the tension, isn't it? We are constantly told it's complicated, or it's the fog of war, or it's a matter of interpretation.
Always it's murky.
This memo argues the opposite. It says, if you know where to look and you know how to do the math, the fog lifts. The law is actually quite clear, and the murkiness is, well, it's a choice.
A choice to make it seem complicated.
Exactly.
So, if you have ever shouted at your TV during a news report thinking, why aren't they charging him? Or conversely, how could they possibly charge him? This deep dive is for you. We are going to walk through the logic step by step.
And this is about understanding the process. For any case, really. This is how a prosecutor is supposed to think. It turns you, the listener, into a juror. Here's the evidence. Here are the rules. You decide.
And warning, we are going to get into the weeds. We're talking ballistics, trajectory analysis, and the specific legal definition of the word willful.
Which is a much, much harder word to define in a courtroom than most people think.
Oh, I bet. So let's open the file. We have to start with the movie in our minds. Before we get to the law, we need the facts. The memo calls this Section 3, the statement of facts. Walk us through the scene. Where are we?
Okay, so visualize this. We are in Minneapolis. It's an enforcement operation.
Yeah.
This isn't a traffic stop where someone ran a red light. This is federal immigration enforcement, ICE and HSI agents.
And that context matters, right? Because these aren't beat cops walking a beat.
It matters a lot.
Yes.
Correct. These agents are geared up. They're on foot. They aren't in patrol cars chasing someone down at high speeds. They are pedestrians with badges and guns, essentially swarming a location. They're approaching a vehicle.
Okay, so Renee Nicole Good is in her vehicle. The agents approach. Now, according to the memo, this starts relatively standard.
Right.
You have commands being shouted, hands up, get out, the usual intensity you see in these body cam videos.
The compliance phase, technically.
Yeah.
But it fails. The de-escalation doesn't happen or isn't attempted effectively, and the situation deteriorates instantly.
And this is where the vehicle starts to move. Now, stop right here, because if I'm listening to the official story, the press release that came out, 10 minutes after the shooting, the narrative is very clear.
Oh, wait, you know the script.
The car became a weapon. It drove at the agent. He had to fire to save his life.
Which is the classic self-defense against a deadly weapon argument.
Yeah.
And it's a powerful one. A 2-ton car beats a human every time. If a car is coming at you, legal precedent generally says you shoot. That is the logic the system relies on.
But Justin Lake's memo says, stop, look at the tape.
Not just look, analyze.
And not just watch it, measure it. This is where the analysis gets really granular. The memo cites frame-by-frame analysis of third-party video, civilian video, and what it reveals is, well, it's not what the press release said.
It changes the geometry of the encounter completely. And I mean specifically the vectors involved, the physics of it. The memo argues that at the moment the shots were fired, the vehicle was not moving toward the agent.
Wait, let me make sure I get this right. The car is moving forward, but the agent isn't in front of it.
That is the crux of it. The analysis places the agent to the side of the vehicle's path. The vehicle is maneuvering away, attempting to flee.
So it's not an attack, it's an escape.
That's what the evidence suggests. The trajectory, and this is a measurable vector using the tire angle and the car's momentum, is taking the car past the agent, not into him.
That is a massive distinction. I mean, huge. Because if I am running away from you, I might be breaking the law, I might be resisting arrest. But am I an imminent threat to your life?
Legally, no. And that is the pivot point. The memo points out that precise positioning, it's not a feeling, it's physics. If the vector of the car doesn't intersect with the position of the agent, the claim, "I thought I was going to be crushed," starts to evaporate.
It has to.
You cannot claim you were about to be run over by a car that was physically driving away from you.
It reminds me of, imagine you're standing on a sidewalk and a car drives past you in the street. You might be close to it, it might be loud and scary, but you aren't actually in the path.
Right.
You don't get to shoot the driver just because they're close.
That is a perfect analogy.
Right.
Proximity is not the same as jeopardy. And the memo adds another layer.
Oh.
The absence of other threats.
Right. What was Miss Gipp doing?
She was in the driver's seat. She didn't have a gun. She didn't have a knife. She didn't display any weapon.
The car was the only weapon.
The car was the only weapon alleged.
Well.
And, just as importantly, there were no bystanders downrange. She wasn't driving toward a crowd of school children. She was driving toward empty space, an escape route.
So the argument becomes, why use lethal force against a driver who is simply trying to leave the scene and who poses no immediate physical threat to anyone?
Exactly. It reframes the entire incident.
It really paints a different picture than the heroic agent stopping a rampage narrative. It sounds more like a chaotic departure.
It sounds like an escape. And under the law, shooting an escapee is a very, very different thing than shooting an attacker.
Okay, so we have the picture. Car driving away, agent shooting anyway. To a layperson like me, that looks bad. But we know the law for cops is different than the law for you and me.
It can be, yes.
They have qualified immunity, they have all these protections. So how does a prosecutor turn looks bad into a federal crime? Because this memo isn't just complaining, it's charging.
You have to build a three-legged stool. If one leg breaks, the case falls over. The first leg is the Constitution.
The big,
Specifically the Fourth Amendment.
which protects us against unreasonable searches and seizures.
Right, and we need to be crystal clear here because people often dissociate this. A bullet is a seizure. When the government puts a piece of lead into your body, they have seized you.
That is a grim way to put it, but I guess it is accurate. You are stopping the person's freedom of movement permanently.
It is the ultimate seizure. And under the Supreme Court's rules, specifically cases like Graham v. Connor, that seizure has to be objectively reasonable.
Objectively reasonable. So it's not about what the officer felt, it's about what a theoretical reasonable officer would have done.
Exactly. You cannot use deadly force just to stop someone from fleeing. You can only use it if, and this is the golden rule, there is probable cause to believe the suspect poses a significant threat of death or serious physical injury.
So fleeing is not fighting.
Precisely. If they run, you chase. You don't shoot. But then we get to the second leg of the stool, which I think is where this memo really shines.
What's
It brings in the DOJ policy.
Now, why does policy matter in a criminal case? I can get fired for breaking policy at my job, but I don't go to jail.
That's a great question. In this context, policy establishes the standard of care. It establishes what the agent knew they were supposed to do.
It sets the bar for what a reasonable officer in that specific agency would know.
You hit the nail on the head. And the DOJ policy on this is surprisingly strict. It explicitly says firearms should not be used solely to disable a vehicle.
Wait, really? Because in movies, shooting the tires or the engine block is practically step one?
In the movies, sure. In real life, it's a terrible idea. Bullets bounce off pavement, they ricochet off engine blocks, they hit bystanders. It is incredibly dangerous and ineffective.
So it's a safety rule more than anything.
It is. But the policy goes further regarding the driver. It says deadly force is only permitted when necessary to protect against an imminent threat. And, this is the duty to move, the policy instructs officers that if a vehicle is coming toward them, they should, where feasible, move out of the path rather than fire upon it.
Move out of the path.
Yeah.
That seems like common sense, but it is actually codified policy.
It is. The logic is simple. Don't stand your ground against a 2-ton machine if you can step aside. Stepping aside removes the threat. Shooting creates a tragedy. And potentially an uncontrolled 2-ton projectile with an incapacitated driver.
Okay, so we have the Fourth Amendment, don't shoot fleeing people, and DOJ policy, don't shoot at cars, move out of the way. Now, let's talk about the charge itself. The memo references 18 U.S.C. Section 242. That sounds incredibly technical.
It is the primary federal criminal civil rights statute. In plain English, it makes it a crime for someone acting under color of law, which means someone wearing the badge using their official authority to willfully deprive another person of their constitutional rights.
So it is a crime for a cop or an agent to use their badge to break the Constitution.
Exactly. But there is a trapdoor in this statute. One specific word that kills most prosecutions before they even start.
I think I know what you're going to say. It's that word willfully.
Yes. Willfully.
See, to me, willful just means you did it on purpose. Like, did you willfully eat that cookie? Yes, I wanted the cookie.
In federal criminal law, it is a nightmare compared to that. To prove willfulness, you don't just have to prove the agent killed her. You don't just have to prove he broke the rules.
You have to prove what was in his head?
You have to prove that he knew what he was doing was a constitutional violation and he did it anyway. You effectively have to prove he had a specific intent to break the law.
That feels impossible. How do you prove what was in a guy's head in a split second? Oh, yes, I'm consciously violating the Fourth Amendment right now. Nobody thinks like that in a gunfight.
And that is why these cases are so rare. That's why prosecutors so often say their hands are tied. But that is also why Justin Lake's memo is so compelling. He lays out a roadmap to prove the unprovable.
Okay, so let's get into the prosecution's case. Part 3. Applying law to fact. How does Lake argue that this wasn't just a mistake, but a crime?
It goes back to that trajectory argument we started with, reasonableness. If the video evidence shows the car was moving away, the imminent threat defense collapses.
Because it's not reasonable to fear something that isn't a threat.
Right. You cannot kill someone for leaving. It is objectively unreasonable to shoot at a car that is driving away from you because that car is no longer a threat to you.
The memo also talks about alternatives, right? It's not
Yep.
just about what he did, but what he didn't do.
Right. Reasonableness is about options. Did the agent have alternatives? The memo argues yes. The agent could have stepped back. The agent could have stepped sideways. The agent could have just let the car go and called for backup.
Which is standard procedure.
Standard procedure. Taking the lethal option immediately, when non-lethal options, like simply moving your feet, were available, makes the shooting unreasonable.
Now, there is a concept in here that I found really fascinating. Officer-created jeopardy. I've heard this term floating around legal Twitter, but what does it actually mean in a courtroom?
It is a powerful legal concept, though it's applied differently in different circuits. Essentially, it means an officer cannot recklessly or unnecessarily place themselves in harm's way and then rely on that self-imposed danger to justify using deadly force.
Can you give us an analogy? Because I feel like this is where the self-defense argument usually gets muddy.
Sure. Think about it like this. Imagine I am a cyclist riding down the bike lane.
Okay, I'm picturing you in the spandex, the helmet, the whole deal.
Let's stick to the physics, please.
Uh-huh.
I'm riding down the lane. Now imagine you're a pedestrian on the sidewalk. You see me coming, you have plenty of room. But instead of staying put, you jump directly into the bike lane, stand inches from my front tire, and then scream, "He's trying to hit me," and punch me in the face.
You'd say, I was crazy, I created the emergency. I can't claim self-defense if I jumped in front of the bike.
Exactly. You cannot manufacture the need for self-defense. The memo argues that even if the agent felt unsafe, he put himself there.
By getting too close.
By getting too close, by not maintaining a safe distance. Remember that DOJ policy, duty to move. It turns the stand your ground logic on its head. When you are facing a 2-ton machine, standing your ground is bad tactics and bad policy.
So the argument is, by crowding the car instead of stepping back, the agent created the very jeopardy he used to justify the shot.
Precisely. If you stand next to a car and then shoot the driver because the car moved, you are responsible for being in that danger zone. You created the jeopardy. Your poor tactics don't give you a license to kill.
Okay, so that handles the unreasonableness. That's the first half of the crime. But we still have that high bar of willfulness. How does Justin Lake argue that the agent knew this was wrong? Because remember, we have to prove he knew he was breaking the law.
This is where the training becomes the evidence. This is the crucial link. The memo points out that the agent was a trained federal officer. He was certified. That means he sat in classrooms. He ran drills. He was specifically trained on that DOJ policy we talked about earlier.
The policy that says don't shoot at cars.
Exactly. He was told repeatedly by his employer, do not shoot at moving vehicles to disable them. Move out of the way. Because he was trained not to do this, Doing it implies a knowing violation.
That is a really interesting argument. It turns the training into a weapon for the prosecution. Basically, you can't say you didn't know better because we have the receipts that we taught you better.
Bingo. It strips away the oops defense. It counters the idea that this was just a mistake made in the heat of the moment.
Because the training is specifically for the heat of the moment.
Correct. Willfulness is inferred when an officer knowingly violates clearly established rules that they were trained on. The combination of the training, the clarity of the policy, and the physical evidence allows a jury to conclude. He knew firing was unlawful, and he pulled the trigger anyway.
So that is the prosecution's roadmap. And honestly, laid out like that, it seems solid. But we have to play fair here. We have to look at the other side. Part 4, the defense. Because if this went to trial, the defense wouldn't just roll over. What are the arguments they would use?
The biggest one, the one we always hear, is subjective fear. Section 6 of the source anticipates this. The defense will put the agent on the stand and he will say, "I feared for my life."
And fear is a powerful thing. If a jury believes the agent was terrified, doesn't that get him off? I mean, who are we to judge his fear?
That is the instinct. But the law is stricter. Fear alone is insufficient. It must be reasonable fear.
There is that word again, reasonable.
It is the cornerstone of the law. If I am afraid of a puppy, that is fear. Genuine fear. But it is not reasonable fear that justifies shooting the puppy.
Right.
The memo argues that the video evidence, the trajectory of the car moving away, destroys the reasonableness of the fear. If the car is leaving, a reasonable officer would not fear imminent death. Therefore, the self-defense claim fails.
What about the split-second decision argument? We hear this all the time. You weren't there. It was the fog of war. Things happen so fast you can't analyze it frame by frame.
The courts do recognize that. It is called the heat of the moment doctrine. You don't judge an officer with the benefit of 20/20 hindsight.
So that sounds like a good defense.
It can be. However, the memo rebuts this by saying that stress does not excuse violating core training.
Right. Pilots make split-second decisions too, but they are expected to follow their training checklists, even under extreme stress.
Exactly. If a pilot ignores the emergency checklist because they panicked and crashes the plane, they are liable. The same logic applies here. If your training for a split-second decision regarding a car is move out of the way, then panic isn't a legal excuse to do the exact opposite.
So the training is the antidote to the fog of war.
It's supposed to be. The fog of war isn't a get-out-of-jail-free card for ignoring the rules of engagement.
There is one more defense mentioned. Supremacy Clause immunity. This sounds like something from a spy movie. I have diplomatic immunity.
It is similar. Federal agents generally have immunity from state prosecution for actions taken while doing their job. It's why a mailman can't get a ticket for double parking while delivering mail, theoretically.
So the agent is shielded because he works for Uncle Sam.
Normally, yes.
Hmm.
But, and this is a huge but, Supremacy Clause immunity does not protect federal officers who exceed constitutional limits.
So the shield has a crack in it.
The shield only works if you are doing the job properly. If the force used was unreasonable, if it violated the Fourth Amendment, the immunity evaporates. You're just a person who shot another person.
You're no longer acting as an agent of the government.
You're acting outside the scope of your authority. The government cannot authorize you to break the Constitution, so that shield disappears.
That brings us to part 5, the conclusion. The memo reaches a verdict.
It does. Justin Lake concludes that, based on the available evidence, there is probable cause.
And probable cause is the standard needed to bring charges, right? It's
Yeah.
not beyond a reasonable doubt yet.
Correct. It's just enough evidence to believe a crime has been committed. He's saying there is probable cause to believe the agent used deadly force in violation of the Fourth Amendment, and probable cause to believe was willful under 18 U.S.C. Section 242.
So in the eyes of this model memo, charges are supported.
Yes. The memo argues that the law isn't ambiguous here. When you layer the video over the policy, the violation is clear. It's a direct contravention of established rules and constitutional law.
And this brings us back to something you mentioned at the very beginning, the interpretation trap. Can we dig into that? Because it feels like that is the bigger message here.
It is. I think it's the whole point of the document.
Yeah.
We often see legal processes stall in these cases. Prosecutors hesitate. Agencies delay releasing footage. Grand juries decline to indict. And they hide behind this guise of interpretation.
Right. They say, oh, we need to interpret the nuance of the moment, or it's a matter of perspective.
A reasonable person could see it differently.
It effectively says that interpretation is being used as a stalling tactic, a way to avoid making a hard decision.
Exactly. Justin Lake is effectively arguing that what is happening is sheer politics, not law. The law is a flowchart. Did X happen? Yes. Does policy forbid X? Yes. Was there an alternative? Yes. Then it is a crime.
It removes the subjectivity.
It attempts to. The memo serves as a proof of concept that criminal charges are supported by the facts, removing the mystery of, can they charge him?
The answer, according to Lake, is yes. They just have to choose to do it.
Right. It argues that the difficulty of the case is a manufactured fiction. The law is clear. The political will is what's murky.
That is a powerful realization. We've gone from a chaotic scene in Minneapolis, shouting, a car moving, shots fired, to a structured, cold, hard legal argument.
Laid out on paper.
We've seen how video evidence interacts with federal policy to strip away the excuses one by one.
And it is important to remember, while this is a model memo, it uses the logic that real prosecutors should be using. It strips away the headlines. It doesn't care about the political leaning of the driver or the agent. It focuses entirely on the statutes and the physics of the encounter.
It is a reminder that the law, when applied correctly, is supposed to be objective. It's supposed to be about accountability.
And transparency. By publishing a memo like this, it allows the public, us, to see how the gears of justice are supposed to turn, so we can ask why they aren't turning in reality. It gives us the vocabulary and the framework to ask better questions.
Before we sign off, I want to leave you with a thought derived from that officer-created jeopardy section we discussed. It really stuck with me.
What is that?
The law says an officer cannot create the danger they then use to justify lethal force. They can't jump in front of the bike and then shoot the cyclist. But if that is the law, why do we so often see tactics that escalate tension rather than diffuse it?
That's a deep question.
Why do we see agents crowding vehicles, shouting conflicting commands, creating that panic that leads to flight?
It raises the question, is the tragedy really about the split-second decision to pull the trigger? Or is the tragedy set in motion minutes before by the decisions made to approach, to crowd, to escalate, by the tactics themselves?
Is the issue the shot? Or is the issue the tactic that made the shot necessary in the officer's mind? If the tactic is flawed, if it violates the principle of not creating your own jeopardy, can the shooting ever be justified? That is something to think about.
It certainly is.
Thanks for listening to The Deep Dive. We'll catch you on the next one.